Okay, hi, I'm Keith Myers. I'm the clinical director here. My official title is Vice President of Clinical and Training Services, but I'm also, for this purposes, I'm the HIPAA privacy official. And so today we're going to talk about HIPAA, and we're going to try and get through this in a half hour. It usually takes me a little bit longer than that, but hopefully because we're taping it, we're going to go through this. And that means that we're not going to have any fun at all with this. HIPAA is deadly boring anyway, and usually I try and make it fun and exciting, but it's just not going to happen today. I'm sorry. So just remove any sharp objects in front of you so when your head hits the table and you pass out from unconsciousness, it won't hurt you too much. In your packet, in your folder, you have mostly what I'm going to go over today. And so we're going to skip over a little bit of the breach notification stuff. I'm not even sure that's part of the package, but we're going to start with just basic overview of HIPAA. And HIPAA requires that all employees be trained in HIPAA at the time of hire and then yearly thereafter. Now, Wellspring is what's called a hybrid entity. And that means that some of our programs are covered under HIPAA and some of our programs aren't covered under HIPAA. Almost every one of you here today, with the exception of one of you anyway, is part of a covered entity program. And so the programs that are covered under HIPAA in this agency are counseling, EAP, and parent-child services. But we give everybody this overview because we think it's important to have an overview of HIPAA, just so that you know what's kind of operating in the background. So, how many of you have had HIPAA training before? Good, then you can help out in all of this, and you'll know all of the answers to my rhetorical questions. So the first question is, HIPAA 1A or 2As? 2As, and what does HIPAA stand for?
Accountability Act.
Yeah, what's the HI?
Oh, health insurance.
Health insurance or health information? Oh, no, you're reading.
Insurance.
Huh?
Insurance?
It's health insurance, and most people think it's health information because health information is such an important part of this, but the actual name of the act is the Health Insurance Portability and Accountability Act, and of 1996. And so when you think about what the internet was like in 1996, which wasn't much, and for those of you who aren't aware, there was a time when there was not an internet. Back in 1996, internet was a dial-up modem kind of thing. It was pretty slow. It was not much of anything. And someone in the federal government said, you know, there's a lot of personal information flying around this thing called the internet, and a lot of it is starting to be healthcare information, and so maybe we should regulate that. And that was really an amazingly forward-thinking kind of thing in 1996. And so, but there are two parts. There are two parts to HIPAA. The first part is the portability part, and that was passed in 1998, I think, and actually 96. And that's the part that allows you to take your insurance and bridge your insurance from one insurer to another. That's what we call COBRA now. Title II, which is what we usually think of as HIPAA, is what's called the Administrative Simplification Act. And of course, in government speak, that means really complicated. But there actually was an attempt in the Administrative Simplification Act to actually make things simpler. And so part of what the Title II of HIPAA was trying to do was to consolidate and standardize the way information about healthcare was transmitted over the internet. And so prior to HIPAA, there were multiple diagnostic codes and diagnostic code references. There were different ways of transmitting information across the internet, so that insurance companies had to keep multiple systems in place to accept all this information. And so the idea was that if we standardize it and make it one way and do it in one way, that insurance companies don't have to keep these multiple systems. They can just have one system, and that will save everybody some money. And so that was actually a well-intentioned, and actually it worked out pretty well. Part of what that means for those of us in the mental health field is that prior to HIPAA, there were what we call procedure codes, CPT codes, and there were numerous CPT codes And more importantly, there were numerous diagnostic codes. So what HIPAA said is that we're going to use the current procedural terminology, CPT, to describe what it is we do, and we're going to use the ICD-9 when this went into existence, the ICD-9, the International Classification of Diseases, as our standard way of diagnosing. Now it's ICD-10. But that meant that the other diagnostic manual in mental health, the DSM, had to then sync up with the ICD-9, which it did. And now the ICD-10 is generally all synced up. One with the DSM-5 and the ICD-10 are all synced up. So basically, though, when we think about HIPAA, we think about privacy. And there really are two parts to privacy. And there's privacy rules and there's security rules. And we're going to spend most of our time on the privacy rules, not on the security rules today. In general, privacy is about who has the right to access and use personally identifiable health information. And so the privacy standards apply to all covered entities. Now, what is a covered entity? A covered entity, it gets a little circular because a covered entity is an organization or an individual who engages in covered transactions. And of course, if you engage in covered transactions, that makes you a covered entity. So does anybody know what a covered transaction is? What an example of a covered transaction is? What covered transactions are what propels you into HIPAA. You can actually practice in healthcare and not have to adhere to HIPAA regulations. But if you engage in a covered transaction, then you have to engage. Then you have to be a covered entity and do all the stuff that HIPAA requires. So does anybody have an example of what would be a covered transaction?
Mental health.
So.
A therapy session.
A what?
A therapy session.
A therapy session. A therapy session just by itself would be a covered transaction?
That's being billed to insurance.
That's being billed to insurance in what way?
Like a Medicaid.
Medicaid is required. You're required to be a covered entity if you're in Medicaid. But what happens is that if you engage in a covered transaction, so let's look at the idea of covered transactions. Covered transaction is any computer-to-computer. If you see it on the second page here. Actually, I kind of got a little bit ahead of myself. So we covered the transaction code set standards. A covered entity is anyone who engages in a covered transaction. A covered transaction is any computer-to-computer transaction of healthcare claims, payment, remittance, benefit information, or health plan eligibility. So it's a computer-to-computer communication that actually triggers the need to be a HIPAA-covered entity. So if you are billing, if you're not billing insurance at all, you don't necessarily have to be a HIPAA-covered entity. If you send in a paper claim to an insurance company and never engage in a computer transaction or computer communication with an insurance company, you don't have to be a covered entity. You can actually practice outside of HIPAA. But if you engage in one covered transaction one time for one client, you are a HIPAA-covered entity for all clients for all time. Okay? So that means if you send in one electronic billing claim for a client, that would be a computer-to-computer transaction. That would put you into HIPAA. But the more subtle ones are if you check eligibility for someone's insurance online. And most insurance companies now will have a portal that you can go into and you can look and see what their eligibility are, what their coverage is and what their plan is. If you go in and do that, that's a covered transaction and that puts you into HIPAA. If you follow a claim online, if you send in a claim and then you want to check on the status of that claim online, that's a covered transaction as well. If you seek pre-authorization for treatment online, that's a covered transaction. So there are really 4 covered transactions that we have to pay attention to that put you into HIPAA. And in fact, we do here at this agency, we do all 4 of those. So we do billing, we check eligibility, we sometimes get pre-authorization online, and we check claim status online. And those are all covered transactions, and that makes us have to adhere to all covered, all HIPAA standards. So in order really to fully understand the privacy standards, we need to understand protected health information, because protected health information is what HIPAA is really trying now to protect. And so generally stated, protected health information is information that's identifiable to a specific individual and is maintained or transmitted by a covered entity in any form, whether it's oral, paper, or electronic. So that means that a chart, whether it's handwritten or electronic, a bill for services, or even a hallway conversation about a client between two clinicians is a conversation involving PHI. And all of that has to be protected and has to be, we have to be mindful of where we're doing that. One of the things that I'm most energized about is making sure that people understand that when you talk to somebody about a client on a cell phone, that's a particularly dangerous situation. Not because most modern cell phones are encrypted, and it's not that people will eavesdrop on the conversation through some electronic means. It's where we tend to use cell phones, which tends to be in public areas. And then because we don't have that feedback loop that comes on a regular telephone, we tend to talk really loud when we're on a cell phone. And so what I always say is that you have to be really mindful if you're talking on a cell phone, particularly about a client, to anybody, because there are a lot of places where that might be heard. I was at the Hayden Planetarium in New York City waiting to go in to see a show, and there was an OBGYN, and there were about 200 people waiting to get in to see this thing, and there was an OBGYN wandering around, kind of walking in a circle on his cell phone, talking to his office about Mrs. Smith's fibroid tumors. And he was naming names, and he was naming diagnoses, and he had no clue that there were 200 people listening to him, and he was talking very loud on his cell phone. And so it was, that was clearly a breach of a violation of HIPAA. But it's a common kind of thing. So we just have to be mindful, and what I say is we need to really be mindful when we're having a conversation on a cell phone or any other time we're not in our office thinking and talking about clients. If the next concept in HIPAA that's really important for everybody to understand is the concept of treatment, payment, and operations. And the reason this is important is that you'll notice now when you go to the doctor, you get a notice of privacy practices. How many of you read your notice of privacy practice when you go to the doctor? Now this is where, as a healthcare consumer, it's probably really helpful for you to know some of the things that are in HIPAA, that are in your notice of privacy practices. Because when HIPAA was instituted, it started out as any information that's conveyed to anybody needs to have a specific authorization to release that information. HIPAA actually, in the final rule, it changed that. And it said now that once you have acknowledged receipt of your doctor's notice of privacy practices, not that you have actually gotten or read the notice of privacy practice, but you've acknowledged receipt of the notice of privacy practices, that the covered entity can then release your information without your further authorization for treatment, payment, and operations. So in other words, your doctor doesn't need your permission to bill an insurance company. You can do that without your permission. Your healthcare organization can compile information about you to make their operations more effective and more efficient. It allows treating physicians or treating entities to talk to one another as long as they're both treating you without your permission. So that's the treatment, payment, and operations piece of HIPAA, that once you sign the notice of acknowledgement of receipt of notice of privacy practices, the covered entity can then go on and talk about you without your permission. And you can object to that. Technically, under HIPAA, you have the right to object to that kind of thing. However, the covered entity under HIPAA is not required to adhere to your objection. Furthermore, in other words, you can say, I don't want you to release my information to an insurance company and don't bill my insurance company. And we can say, that's fine. We understand that you don't want us to do that. but we're going to do it anyway, and that's perfectly legal. The other two things is that many notice of privacy practices will say that they will release your protected health information for purposes of marketing and fundraising. How many of you have seen that in a notice of privacy practices? Because it's often in there. So what does that mean? Well, for instance, hospitals often have a foundation for uncompensated care, where they raise money for uncompensated care. And so a lot of times they will release your name. It's usually not anything about what you were there. If you were in a hospital for something, they'll release your name to the foundation so that the foundation can then contact you and say, we know you just had this wonderful experience in this hospital. Wouldn't you like to donate for uncompensated care? And I've actually had that notification beat me home from the hospital. And in fact, I got an email. I took an elderly aunt into the urgent care clinic at one of the local hospitals. And when I got home, I was her her authorized caregiver. I had a notice on my email from the foundation of the hospital after I took her home from the urgent care clinic. She wasn't even in overnight, saying, would you like to donate? So, and you can object. You can say, I don't want you to release my name to the foundation. And I don't want you to send my name to other organizations or to anybody else for, or even within your hospital for marketing purposes. So a lot of hospitals, for instance, have child care programs, parenting programs. And so if you go into a hospital, have a baby in a hospital, a lot of times they will say, gee, here are all the services we have for new mothers, for new parents, and things like that. And that's an internal marketing thing. They can't release it outside of the hospital without your permission, except under certain circumstances. But you should always pay attention to what's in the notice of privacy practices, as they will tell you what they're going to release that information for. And you can object. You can object in writing. Again, they don't have to adhere to that, but most of them will. Any questions about that? Because that's as a consumer, you should probably know that.
So I did have one question. So when it's talking about being able to exchange PHI for like operations, right? So allows treating entities to talk to each other without authorization if they're both treating you. That's within an organization, right?
That's correct. Well, it's both within and outside. Technically, if a person has a primary care physician, you can talk outside. You can talk to a primary care physician
Without the client's authorization?
That's right. Now, our internal standard is that you always get an authorization to talk to an outside entity. However, we also reserve the right to talk to that outside entity without that authorization in cases of emergency. What we've done with our internal psychiatrists, though, when our psychiatrists give their disclosure statement to clients, we say in that disclosure statement, we will talk with your therapist. So we have essentially told our clients internally, for our own internal psychiatrists, that we will exchange information with psychiatry. And we made that decision consciously and intentionally.
So that they would know.
So that they would know, that's right, that's right. And, clients, I don't think we've ever had any of our clients object to doing that. So technically, if they did, we'd have to take that under consideration. We might, under certain circumstances, say, yeah, it's fine, we won't do that. But, so once the client has signed the notice of privacy practices, we can release information for treatment, payment, and operations. Our policy is to try and get, whenever possible, to get an authorization to talk with any outside entity. And the basic rule is you don't release information outside of treatment, payment, and operations without an authorization to do so. So the notice of privacy practices, when you go into what we have, and when you go into a physician's office, that tells you how they're going to use your protected health information. So what HIPAA did when it went into effect is it established a floor. So prior to HIPAA, there were 50 different ways that protected health information was being addressed. Each state had its own privacy standards. Some of them didn't have any privacy standards. Washington State actually, at the time of HIPAA, had pretty rigid actually most of the standards in Washington State were higher than the HIPAA standards when they went into effect. But HIPAA set the floor and says you can't fall below this floor. You can always rise above the floor. You can have policies and procedures that are more stringent than HIPAA, that protect client information more, or that give patients better access to their own records, but you can't fall below the HIPAA floor. So it included the right to receive the notice of privacy practices and opportunity to object or opt out of certain communications. It gave people the right to access their PHI and to make amendments to the protected health information. And it tried to make it easier for patients to be able to access their protected health information. It gave them the right to inspect and copy their protected health information. And they have, like I said, they have the right to amend their record for as long as the record is maintained. So basically what HIPAA says is that you can't restrict unduly people having access to their information. You can't require them to come in and sit down with you in order to review the protected health information. If they say, I want you to send it via Skype or the internet or whatever, and we say, gee, that's not probably the best way to do it, they say, I want it anyway, we have to accommodate those alternative needs. So we really have very little ability to restrict people's access to the protected health information. There is one exception in the mental health world on that, and that's psychotherapy notes. Psychotherapy notes require a specific authorization for us to release. They don't fall under the treatment, payment, and operations exception. So in order for us to release psychotherapy notes, which are kind of the raw data of a psychotherapy session, they're what we used to call process notes. Generally they have a higher level of protection. Psychotherapy notes belong to the clinician, not to the client. However, in Washington State, there is a little slight glitch in that. There were some new rules that were put into effect in Washington State about 2 years ago, and there was some language left out of the law when they amended it that doesn't exempt clients from being able to access their psychotherapy notes. So under HIPAA, under the federal law, the psychotherapy notes belong to the clinician, and clients don't automatically have access to their own psychotherapy notes. Under Washington state law, they do. So psychotherapy notes under Washington state law don't have the same level of protection that they do well, they have a higher level of protection under Washington state law, if you will, than they do under federal law. Because under federal law, you can restrict a client's access to psychotherapy notes. Under Washington state law, you can't restrict a client's access to psychotherapy notes. But other than that, psychotherapy notes cannot be released except with client permission or court order. Any questions about it? It's a little bit of a glitch in Washington state law. There were a couple of other things under HIPAA that were kind of interesting when it was first implemented. The first one of those is the concept of minimum necessary. And basically what minimum necessary says is that when you get a request for information, or when you release information to a third party, you should only release the minimum amount of information necessary in order to convey whatever needs to be conveyed. And so if you do, no, it's over here. That's okay. So if you do release information, and if you get a release of information in the mail, the release of information usually has specific information as to what should be released. And so if a lot of times they don't want the whole record. And so it's important for us to pay attention to what the release says and to release only the minimum amount of information necessary in order to fulfill the request. So if the request says, I want dates of service, don't release the whole record, just release dates of service. Pay very close attention to that so that we don't give more information than is really authorized. And so the idea of minimum necessary is a really important one for us to always keep in mind, that we We don't always necessarily release an entire record. We release only the part that is required by the release. I'm going to skip over breach notification, but the important thing about breach notification is that if information, protected health information, is accidentally released, and that could be our servers are hacked into, it could be that we lose a case file, it could be that someone comes in and opens up our file cabinets and takes our files out, which does never happen. That we're required to inform the people whose case records were compromised that their case records were compromised. And the bigger the breach, the more people whose records are released, the bigger the response has to be from the organization. And so there are very specific requirements that will take hours for us to go through. Just note that if a case file or any protected health information is ever released, there's certain processes we have to go through. And we've had a couple of very small releases, but we've had to go through these specific procedures. So, and they're detailed in here, but you need to know them right now. There are a couple of other administrative requirements. Actually, there's one other thing that I want to talk about before I do that, and that's the concept of business associate. When HIPAA first went into effect, someone brilliantly said, you know, there are sometimes other entities that aren't covered entities that have access to health information. So when we have an attorney or an auditor, auditors come in, we're audited every year, auditors come in and they actually look at our case files, but they're not covered entities. Attorneys aren't covered entities. Computer repair people who sometimes have access to our database aren't covered entities. And so what do we have to do to protect the health information that they see when they're actually looking at or working with our records? And so that's where a business associate agreement comes in. A business associate agreement extends the coverage of HIPAA, extends HIPAA requirements to non-covered entities. And so it's incumbent upon us to have business associate agreements with anyone who may have access to our protected health information who is not also a covered entity. So we have about a half a dozen, or probably more like a dozen, business associate agreements with various attorneys, legal firms, data repair, computer repair people, folks like that who may have access to our protected health information. And it makes them act as though they are a covered entity. Does anybody know if there's a conflict between state law and federal law, as there is at times in Washington State? Which law trumps? How do you decide which law you follow? So let's say under Washington State law you have to release information within 15 days, and under HIPAA you have to release it in 30 days.
Go with the strongest one. So
Okay.
you'd have to release in 15.
So you would have to release in 15 days. So you go with the law that is what HIPAA says is more stringent. And by stringent, it means gives clients greater access to their own record, or protects that information from a third party greater. So you have to compare the state law with the federal law, and you have to make this determination as to which is more stringent. And then you go with the stringent law. Generally, all protected health information must be reasonably protected, locked up in file cabinets, locked up overnight. We have to be very vigilant about making sure that our information is covered and it's not left out, and it's protected when we're not here. Anyone has the right to complain if they don't feel like me or any other covered entity is adhering to law. And that includes all of you. If you feel like something that we're doing doesn't adhere to HIPAA, you have the right to complain. You can complain to the Department of Health and Human Services or to the HIPAA COPS, which is the Office of Civil Rights. I would prefer that you came to me first. That would be my preference, but I can't make you do that. But if you see something that you think we're not doing right, then I would urge you to come to me. But if you feel like that's not an appropriate way to do that, you can file a complaint, or any of our clients can file a complaint. If a complaint is filed against us, we're required to cooperate with the investigation, to open up our policies and procedures, to open up our facilities, our books, our records, and our protected health information so that they can do an investigation on that. I will say that over time, the HIPAA COPS, the Office of Civil Rights, has gone in the early days from saying, okay, well, this is a complicated law. We will help educate you if there's a complaint filed against you. We will educate you. We're about 15 years into HIPAA now, and the Office of Civil Rights is saying, you know, if you haven't figured it out by now, it's on you, it's not on us. And so they're much more into punishing now. So they're levying fines, and they can levy fines up to $1.5 million. And they have levied fines up to $1.5 million, and they've levied fines up to $100,000 on very small organizations. And so they have very little tolerance for non-adherence to HIPAA anymore. So it's important for us to make sure that we understand all of that and to ask questions if we have any questions about it. So with that, do you have any questions about